Hello at magandang gabi sa lahat at ito na naman ulit si Lola Ray para sa isa na namang edisyon ng in layman's term. Okay? So itutuloy lang natin ngayon yung nabinbin natin na pagbabasa. Okay? Pagbabasa para sa masa ng family code, no? Okay? Family code is under the civil law. So ituloy po natin, nagtapos tayo last time sa article 101 ng Family Code. Ngayon basahin naman natin yung section 6 ng Family Code pa rin, liquidation of the absolute community, assets and liabilities. So magsisimula po itong ating babasahin sa article 102 of the Family Code. Upon dissolution of the absolute community regime, the following procedure shall apply. Number 1, an inventory shall be prepared, listing separately all the properties of the absolute community and the exclusive properties of each spouse. Okay? So pagka na-dissolve na, kunwari, na-annul na kayo, na-dissolve na yung absolute community of regime na mag-asawa, ito daw yung mga procedure na mag-a-apply. Unang-una, magkakaroon ng inventory para dun sa absolute community regime nyo, listing separately all the properties of the absolute community and the exclusive properties of each spouse. Madalas na exclusive property yan, yung sasakyan na ginagamit ng isa sa inyo, yung mga minana ninyo siguro, kung di ako nagkakamali. Exclusive property yan. Number 2, the debts and obligations of the absolute community shall be paid out of its assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties in accordance with the provisions of the second paragraph of Article 94. Siyempre, magbabayad na kayo ng utang. Number 3, whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. Okay. Pagka matapos nyo magbayad ng utang, yung matitira na yon ay paghahatian nyo na. Number 4, the net remainder of the properties of the absolute community shall constitute its net assets, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements, or unless there has been a voluntary waiver of such share provided in this code. For purpose of computing the net profits subject to forfeiture in accordance with Articles 43, number 2 and 63, number 2, the said profits shall be the increase in value between the market value of the community property at the time of the celebration of the marriage and the market value at the time of its dissolution. Number 5, the presumptive legitimacy of the common children shall be delivered upon partition in accordance with Article 51. So bakit yung presumptive na mana i-deliver na sa mga bata? Kasi magsi-separate na kayo eh. Okay? So it shall be delivered to the common children ng mag-asawa. Number 6, unless otherwise agreed upon by the parties in the partition of the properties, the conjugal dwelling, and the lot, yung lote, on which it is situated, shall be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother, unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking in consideration the best interests of said children. Okay? Lagi po nating tatandaan na ang laging inuuna ng korte ay yung interest ng mga bata. Article 103. Upon the termination of the marriage of death, the community property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the community property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse If upon the lapse of the 6 months, wait lang ha, saan na ako? If upon the lapse of the 6 months period no liquidation is made, any disposition or encumbrance involving the community property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage o kinasal siyang muli without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. Ibig sabihin, pagka namatayan ka ng asawa, isa yun sa mga ground para ma-dissolve ang inyong absolute community ng inyong ari-arian. Kung hindi ka sumunod sa mga requirements ng liquidation na pareho doon sa nakasaad dito sa liquidation ng mga namatay, yung susunod mong magiging asawa magiging automatic na mandatory regime, magiging mandatory sa inyo yung separation of property kung hindi ka susunod dito sa sinasabi ng provision na ito. Article 104, whenever the liquidation of the community of the properties of two or more marriages contracted by the same person before the effectivity of this code is carried out simultaneously, the respective capital, fruits, and income of each community shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which community the existing properties belong, the same shall be divided between the different communities in proportion to the capital and duration of each. Tungo naman tayo sa Chapter 4, yung conjugal partnership of gains. Ano naman itong conjugal partnership of gains? Section 1, yung general provisions niya na magsisimula sa Article 105 of the Family Code. In case the future spouses agree in the marriage settlements that the regime of conjugal partnership gains shall govern their property relations during marriage, the provisions in this chapter shall be of supplementary application. Okay. The provisions of this chapter shall also apply to conjugal partnerships of gains already established between spouses before the effectivity of this code, without prejudice to vested rights already acquired in accordance with the Civil Code or other laws as provided for in Article 256. Yeah, mas komportable. Okay. Article 106. Under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, products, fruits, and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them unless otherwise agreed in marriage settlements. Okay? Yun ang ibig sabihin daw ng conjugal partnership of gains. Yung mag-asawa, ilalagay nila yung mga kita. Kunwari, may lote ako, may lote rin yung asawa ko. Yung kita ng lote ko, yung kita ng lote niya, pagsasamahin namin doon sa common fund naming dalawa. Kung maghiwalay man kami, upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided o hahatiin equally between them, unless otherwise agreed in the marriage settlements. So, sa akin parang maganda itong sa mag-asawa, itong conjugal partnership of gains. Okay? Kasi hindi maapektuhan yung mga personal ninyong pag-aari, mga lote ninyo, sa inyo pa rin yun. Tapos, ang partnership nyo, yung kita lamang nun, yun yung hahati-hatiin ninyo. Yun yung ilalagay ninyo dun sa inyong common fund. Article 107, the rules provided in Articles 88 and 89 shall also apply to conjugal partnership of gains. Article 108, the conjugal partnership shall be governed by the rules on the contract of partnership in all that is not in conflict with what is expressly determined in this chapter or by the spouses in their marriage settlements. Section 2, exclusive property of each spouse. Article 109, nagsisimula yung section na yan. The following shall be the exclusive property of each spouse. O ito ha, kung sakaling wala man kayong agreement, kung sakaling kinasal kayo, matik, absolute community kayo, ito raw yung magiging exclusive property nyo. Ito yung hindi pwedeng pakialaman ng asawa nyo. Okay, number 1, that which is brought to the marriage as his or her own. So, kunwari, kinasal ako, dinala ko sa marriage na yon yung bahay o yung sasakyan ko, yung mga gamit ko, akin yon. Number 2, that which is that which each acquires during the marriage by gratuitous title. So, kunwari sa akin, may binigay yung tatay ko na para sa akin, sa'yo na yung bahay na yan. Tapos sa asawa ko naman, may binigay sa kanya ng ang nanay niya na, sa'yo na yung bahay na yan. O, sa amin yon exclusive. Hindi kasali sa conjugal partnership yon. Number 3, that which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses. So, kunwari, inaisanla yung isang dati ko ng pag-aari, tapos binawi ko, akin lang yon. Or nakipag-trade ako, pinalit ko yung motor ko sa isang tricycle, akin lang yon. Number 4, that which is purchased with exclusive money of the wife or of the husband. O, syempre kung ano yung binili mo, sa'yo yun. Okay? Article 110. The spouses retain the ownership, possession, administration, and enjoyment of their exclusive properties. Either spouse may, during the marriage, transfer the administration of his or her exclusive property to the other by means of a public instrument which shall be recorded in the registry of property of the place the property is located. Article 111. Either spouse may mortgage, encumber, alienate, or otherwise dispose of his or her exclusive property. So kung yung sarili mong pag-aari na hindi makakaapekto sa pamilya mo, ay pwede mong isanla o pagkakitaan o ibenta. Basta ang keyword is hindi sariling pag-aari mo to at hindi kasali dun sa absolute community mo. Nung asawa mo. So example, akin itong bahay na ito, dito ko tinira yung asawa at anak ko. Hindi ko to basta pwedeng isanla o ibenta. Kasi dito sila nakatira eh. So yun na lang yung magandang guiding principle na tandaan natin. Article 112, the alienation of any exclusive property of a spouse administered by the other automatically terminates the administration over such property, and the proceeds of the alienation shall be turned over to the owner spouse. Yan. Okay. Binenta ko yung exclusive property ko, di akin yun. Article 113, property donated or left by will to the spouses jointly and with designation of determinate shares shall pertain to the donee spouses as his or her own exclusive property, and in the absence of designation, share and share alike without prejudice to the right of accretion when proper. So, mag-asawa kayo, merong isang will, kasama ako at yung asawa ko, nakalagay sa will, itong lote na to sa'yo, Lolo Ray, itong lote na to sa asawa mo. Malinaw yun, exclusive property nyo yun. Article 114, if the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse whenever they have been advanced by the conjugal partnership of gains. O sandali lamang, hanapin natin ang ibig sabihin ng onerous. Okay, para lang hindi tayo magkagulo-gulo. Onerous. Sabi niya, donated. Onerous. Ano ibig sabihin nun? What the fudge? Tingnan natin ha. Onerous. Ito. Involving an amount of effort and difficulty that is oppressively burdensome. Okay, so i-donate sa'yo with an obligation. O, kunwari, may donate na lote sa akin, obligasyon kong bayaran yung amilyar nun. O, di ba? O, onerous donation. O, ano ibig sabihin? Para mas malinaw, ibig sabihin ng onerous donation. O, sabi rito sa isang case, onerous donation is not covered by Article 749. Okay? Tingnan natin, basahin nga natin para maintindihan natin yung essence ng onerous donation. An onerous donation is not covered by Article 749. There is no need for a public instrument. A private document is enough to make an onerous donation valid. Okay? Tingnan natin yung ruling ng Korte Suprema. Wait lang. Ang haba naman kasi ito mga kaso-kasong ito. Ang hirap intindihin. May ads pa. Hindi ka? Halibag na nga yan. Basta na-define na natin. Hirap maghanap-hanap ng mga onerous donation example na lang para mas malinaw. Okay, wait lang ha. Okay. Ito, ulitin natin. A donation, ang onerous donation is burdened with charges imposed on the donee that result in a material advantage of the donor. Okay? So example daw, Mr. A donated a parcel of land to Mr. B for the establishment of his own business. After 5 years, Mr. B gave Mr. A luxury car in return for the success of his own business. The luxury car is the onerous donation since the cost of the car is more than the parcel of the land which Mr. A gave to Mr. B. Okay, so malinaw doon sa example natin, luminaw yung ibig sabihin ng onerous donation. Okay? Doon sa example na yun, di ba? Kunwari, binigyan ako ni Mr. A ng lote para tayuan ko ng negosyo ko. Tinayuan ko ng negosyo ko, kumita ako, tapos ang ginawa ko nung kumita na ako, binigyan ko siya ng luxury car na mas mahal pa dun sa loteng binigay niya sa akin. Yun ay onerous donation. Okay? Ano naman ibig sabihin ng gratuitous? Minsan nalilito tayo. Ang lamang lang minsan sa atin, hindi natin alam yung mga meaning eh. Diba? Ang lengguwahe ng batas ay kailangang ipaliwanag talaga in layman's term para maintindihan. Gratuitous or ibig sabihin uncalled for, lacking good reason, given or done free of charge. So yun yung binigay sa'yo gratuitously. Ibig sabihin, binigyan ka ng something given or done free of charge. Yun ang ibig sabihin ng gratuitous. So may dalawa tayo na tutunan ngayon. Yung onerous donation, yung ibig sabihin ng onerous and gratuitous. Okay? So ulitin natin Article 114 ng Family Code. If the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse. Yung nakatanggap ng donasyon whenever they have been advanced by the conjugal partnership of gains. Article 115, retirement benefits, pensions, annuities, gratuities, use of frocks, and similar benefits shall be governed by the rules on gratuitous or onerous acquisitions as may be proper in each case. So malinaw na sa atin ang ibig sabihin ng gratuitous or onerous. Section 3, conjugal partnership property. Article 116 of the Family Code pa rin. All property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses is presumed to be conjugal unless the contrary is proved. Okay? Presumed to be conjugal. Yung mga ari-ari ang makukuha ninyo within marriage unless meron kayong yung nag-govern kayo ng ibang property regime. Article 117, the following are conjugal partnership properties. Number 1, those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership or for only one of the spouses. Ito yung mga conjugal partnership properties. Number 2, those obtained from the labor, industry, work, or profession of either or both spouses. Ito yung mga conjugal, kaya hindi dapat pag-awayan. Number 3, the fruits, natural, industrial, or civil, due or received during the marriage from the common property, as well as the fruits from the exclusive property of each spouse. Number 4, the share of each spouse in the hidden treasure, which the law awards to the finder or owner of the property where the treasure is found. Okay? Yan ay kinukonsidera na ah, common property. Uh, Number 5, those acquired through occupations such as fishing or hunting. Number 6, livestock existing upon the dissolution of the partnership in excess of the number of each kind brought to the marriage by either spouse. And number 7, those which are acquired by chance, such as winnings from gambling or betting. However, losses therefrom shall be borne exclusively by the loser spouse. So malinaw yun ha. Kung ikaw nanalo ka sa sugal, makikinabang ang family mo sa napanalunan mo. Kung ikaw naman natalo, ikaw lang, hindi mo pwedeng isanla, ha? Yung mga ari-arian na pinakikinabangan ng pamilya mo. Kaya sa mga nagpapamilya, kahit na wala ka pang pamilya, iwasan nyo po ang droga at sugal. Sus Mario Joseph. Article 118. Property bought on installments, paid partly from exclusive funds of either or both spouses and partly from the conjugal funds, belongs to the buyer or buyers if full ownership was vested before the marriage, and to the conjugal partnerships if such ownership was vested during the marriage period. In either case, any amount advanced by the partnership or by either or both spouses shall be reimbursed by the owner or owners upon liquidation of the partnership. Article 119. Whenever an amount or credit payable within a period of time belongs to one of the spouses, the sums which may be collected during the marriage in partial payments or by installments on the principal shall be exclusive property of the spouse. However, interests falling due during the marriage on the principal shall belong to the conjugal partnership. Okay. Article 120, the ownership of improvements, whether for utility or adornment made on the separate property of the spouses at the expense of the partnership or through the acts or efforts of either or both spouses, shall pertain to the conjugal partnership or to the original owner's spouse, subject to the following rules. When the cost of the improvement made by the conjugal partnership and any resulting increase in value are more than the value of the property at the time of the improvement, the entire property of one of the spouses shall belong to the conjugal partnership. So malinaw ito. Merong property ako. In-improve ng conjugal partnership, kunwari namin ng asawa ko. Yung improvements na nilagay doon is mas malaki kumpara sa halaga ng aking ari-arian. Itong ari-arian ko ay mapapabilang na sa conjugal partnership, subject to reimbursement of the value of the property of the owner's spouse at the time of the improvement. Otherwise, said property shall be retained in ownership by the owner's spouse, likewise subject to reimbursement of the cost of the improvement. So kung ayaw ko mailagay sa absolute community of sa conjugal property namin, di bayaran ko doon yung halaga ng improvement to sa ari-arian ko. Section 4, charges upon the obligations of the conjugal partnership. Article 121, the conjugal partnership shall be liable for, number 1, the support of the spouse, their common children, and the legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. Alam ko, natapos na tayo sa support. Number 2, all debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the conjugal partnership of gains or by both spouses or by one of them with the consent of the other. So lahat daw ng utang at obligasyon na contracted during the marriage by the designated administrator spouse para sa benepisyo ng conjugal partnership of gains or by both spouses or by iisa lang sa kanila, pero kailangan may consent nung isa. Number 3, utang, debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have benefited. O basta nakinabang ang pamilya mo, liable ka ron. Number 4, All taxes, liens, charges, and expenses, including major or minor repairs upon the conjugal partnership property. Number 5, all taxes and expenses for mere preservation made during the marriage upon the separate property of either spouse. Number 6, expenses to enable either spouse to commence or complete a professional, vocational, or other activity for self-improvement. So, kunwari, meron akong asawa, kinuha ko sa conjugal partnership namin yung pagpapaaral ko ng law. So, para naman sa kinabukasan ng pamilya namin yon. So, liable yung conjugal partnership doon. Or training ng asawa mo na makikinabang naman pamilya ninyo. Number 7, antinuptial debts of either spouse insofar as they have redounded to the benefit of the family. O yung mga utang nyo matapos kayong ikasal na nakinabang ang buong pamilya. Number 8, the value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. And number 9, expenses of litigation between the spouses unless the suit is found to be groundless. So, pinakamagandang payo ko, kasal man kayo o hindi, magsama kayo ng may respeto sa isa't isa. At yung anak nyo, legitimate man o hindi, iwanan nyo siya nang wala kayo sanang pinagkakautangan para hindi siya kawawa. Kasi yun pa lang, solved na siya di ba? Pero kung mag-iiwan kayo na may problema, kahit na legal na anak pa yan, kawawa yan. If the conjugal partnership is insufficient to cover the foregoing liabilities, the spouses shall be solidarily liable for the unpaid balance with their separate properties. Okay? Article 122 of the Family Code pa rin. The payment of personal debts contracted by the husband or the wife before or during the marriage shall not be charged to the conjugal properties partnership except insofar as they redounded to the benefit of the family. Tandaan natin, basta nakinabang ang buong pamilya, it shall be charged do sa conjugal partnership. Kumbaga, inutang para sa pangkalahatang kapakanan. So, dun sa joint, sa common fund nyo, liable yon, nabayaran yung utang na yun. Neither shall the fines and pecuniary indemnities imposed upon them be charged to the partnership. So, yung mga fines, kunwari ako, may traffic violation ako, hindi kailangan kunin sa conjugal partnership yon, yung pambayad doon. However, the payment of personal debts contracted by either spouse before the marriage, that of fines and indemnities imposed upon them, as well as the support of illegitimate children of either spouse, may be enforced against the partnership assets after the responsibilities enumerated in the preceding article have been covered, if the spouse who is bound should have no exclusive property, or if it should be insufficient, but at the time of the liquidation of the partnership, such spouse shall be charged for what has been paid for the purpose above mentioned. Okay, sandali lamang. Okay, so kayo muli nagbabalik. Tungo naman tayo sa Article 123. Whatever may be lost during the marriage in any game of chance or in betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser, magbabayad doon yung talunan, at hindi ang conjugal shall not be charged to the conjugal partnership. But any winnings therefrom shall form part of the conjugal partnership property. So maliwanag yun Section 5, Administration of the Conjugal Partnership Property. Article 124, the administration and enjoyment of the conjugal partnership shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. So ang mga ibabaw lagi yung sinasabi ng lalaki. Pero subject ito sa remedyo ng korte. Pwedeng pumunta yung babae sa korte at kung nakita ng korte na dapat yung babae ang magdesisyon, bibigyan siya ng remedyo nito. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the conjugal properties, The other spouse may assume sole powers of administration. Saan ba natin nabasa ito? Nabasa ko na ito. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. So, kunwari, may legal kang asawa. Dalawa kayo. Naging incapacitated ka. Ang magiging administrator bali ng property mo, yung asawa mo. Pero hindi niya pwedeng basta ibenta o isanla yung mga ari-arian nang wala kang pahintulot o nang walang pahintulot yung korte. Ano mang gagawin niya doon sa inyong mga conjugal property shall be void. Okay, so yung mga asawa, magtino kayo ha. Marami kasing asawa na salbahe eh. Nung napunta sa kanya yung pagdidesisyon, biglaan na lang binenta-benta yung mga gamit para sa bisyo. Mariosep. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerors. Article 125. Neither spouse may donate any conjugal partnership property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the conjugal partnership property for the charity or on occasions of family rejoicing or family distress. Section 6. Dissolution of conjugal partnership regime. Article 126. The conjugal partnership terminates, number 1, upon the death of either spouse. Number 2, when there is a decree of legal separation. Number 3, when the marriage is annulled or declared void. Or number 4, in case of judicial separation of property during the marriage under Articles 134 to 138. Article 127. The separation in fact between husband and wife shall not affect the regime of conjugal partnership except that, number 1, the spouse who leaves the conjugal home or refuses to live therein without just cause shall not have the right to be supported. Number 2, when the consent of one spouse by any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. Number 3, in the absence of sufficient conjugal partnership property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon petition in summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits of or proceeds thereof to satisfy the latter's share. Article 128. If a spouse without just cause abandons the other or fails to comply with his or her obligation to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the conjugal partnership property, subject to such precautionary conditions as the court may impose. So kung inabando na ka pala ng iyong asawa, pwede ka mag-petition for the receivership. Ako, yun ang i-advise ko, receivership or to be the sole administrator of the conjugal partnership of property, no? Obligation to the family mentioned in the preceding paragraph refer to marital, parental, or property relations. A spouse is deemed to have abandoned the other. Ito, masasabi mong inabandon na yung isang asawa kapag when he or she has left the conjugal dwelling without intention of returning. The conjugal spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. Section 7. Liquidation of the conjugal partnership assets, and liabilities. Article 129. Upon the dissolution of the conjugal partnership regime, the following procedure shall apply. Number 1, an inventory shall be prepared, listing separately all the properties of the conjugal partnership and the exclusive properties of each spouse. Number 2, amounts advanced by the conjugal partnership in payment of personal debts and obligations of either spouse shall be credited to the conjugal partnership as an asset thereof. Number 3, each spouse shall be reimbursed for the use of his or her exclusive funds in the acquisition of property or for the value of his or her exclusive property, the ownership of which has been vested by law in the conjugal partnership. Number 4, the debts and obligations of the conjugal partnership shall be paid out of the conjugal assets. In case of insufficiency of said assets, The spouses shall be solidarily liable for the unpaid balance with their separate properties in accordance with the provisions of paragraph 2 of Article 121. Number 5, whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. Number 6, unless the owner had been indemnified from whatever source, the loss or deterioration of movables used for the benefit of the family belonging to either spouse, even due to fortuitous event, shall be paid to said spouse from the conjugal funds, if any. And number 7, wala pa pala. Number 7, the net remainder of the conjugal partnership properties shall constitute the profits, which shall be divided equally between husband and wife unless a different proportion or division was granted upon in the marriage settlements, or unless there has been a voluntary waiver or forfeiture of such shares provided in this code. Number 8, the presumptive legitimes of the common children shall be delivered upon the partition in accordance with Article 51. Number 9, in the partition of the properties, the conjugal dwelling and the lot on which it is situated shall, unless otherwise agreed upon by the parties, be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking into consideration the best interest of said children. Ang dami na nating binabasa, laging sinasabi, the best interest of the children. Article 130, upon the termination of the marriage by death, the conjugal partnership property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. Nakailang basa na tayo rito? Parang pare-parehas lang yung nakasulat sa mga provision ng family code. Ulit-ulitin na natin para matanim, di ba? If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the conjugal partnership property either judicially or extrajudicially within 6 months from the date of the deceased spouse. If, upon the lapse of the 6-month period, no liquidation is made, any disposition or encumbrance involving the conjugal partnership property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. Kabasa ko lang yun a while ago. Deja vu. Article 131. Whenever the liquidation of the conjugal partnership properties of 2 or more marriages contracted by the same person before the effectivity of this code is carried out simultaneously, the respective capital, fruits, and income of each partnership shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which partnership the existing properties belong, the same shall be divided between the different partnerships in proportion to the capital and duration of each. Article 132. The rules of court on the administration of estates of deceased persons shall be observed in the appraisal and sale of property of the conjugal partnership and other matters which are not expressly determined in this chapter. Okay. So nagtutulungan laging rules of court tsaka yung family code, no? Article 133. From the common mass of property, support shall be given to the surviving spouse and to the children during the liquidation of the inventoried property and until what belongs to them is delivered. But from this shall be deducted that amount received for support which exceeds the fruits or rents pertaining to them. Chapter 5, Separation of Property of the Spouses and Administration of Common Property by one spouse during the marriage. Uy, magiging administrador o tagapangasiwa ng property yung isa sa mag-asawa. Article 134, in the absence of an express declaration in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. Lagi nating tatandaan, pag kinasal yung dalawa at wala naman kayong prenuptial agreement, automatic absolute community of property kayo. Article 135, any of the following shall be considered sufficient cause for judicial separation of property. O kailan nga lang ba pwedeng ibigay ng korte na maging judicially separated ang inyong property? Kung kayo naman nagsimula as absolute community. Number 1, that the spouse of the petitioner has been sentenced to a to a penalty which carries with it civil interdiction. So, tingnan muna natin ano ibig sabihin ng civil interdiction. Civil interdiction. Sandali. Basahin natin yung kahulugan niya. Civil interdiction is a legal restraint upon a person incapable of managing his estate because of mental incapacity from signing any deed or doing any act to his own prejudice without the consent of his curator or interdictor. Civil interdiction is an accessory penalty imposed upon a person sentenced with a principal penalty not lower than reclusion temporal, ranging from 12 years and 1 day to 20 years. Civil interdiction deprives the following rights to the offender. Number 1, parental authority, guardianship as to the person or property of any ward, marital authority, manage his properties, dispose of such property by an act or conveyance inter vivos. So, yan ang ibig sabihin ng civil interdiction. Malinaw, ha? Okay? So, ang isa sa mag-asawa ay nasentensyahan na isang krimen which carries with it civil interdiction. Yun yung define natin. Hindi na ground na yon para sa judicial separation of property. Number 2, that the spouse of the petitioner has been judicially declared an absentee. Number 3, that loss of parental authority of the spouse of petitioner has been decreed by the court. Number 4, that the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family as provided for in Article 101. Number 5, that the spouse granted the power of administration in the marriage settlements has abused that power. And number 6, that at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. In cases provided for in numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. Okay? Article 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains and for the separation of their common properties. All creditors o yung mga pinagkakautangan of the absolute community or of the conjugal partnership of gains, as well as the personal creditors of the spouse, shall be listed in the petition and notified of the filing thereof. The court shall take measures to protect the creditors and other persons with pecuniary o yung may monetary, may interest sa kaching-kaching, pera. Article 137, once the separation of property has been decreed o naipag-utos na ng korte, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with this code. During the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. Article 138, after dissolution of the absolute community or of the conjugal partnership, the provisions on complete separation of property shall apply. Article 139, the petition for separation of property and the final judgment granting the same shall be recorded in the proper local civil registries and registries of property. Article 140, the separation of property shall not prejudice the rights previously acquired by creditors. Article 141, the spouses may, in the same proceedings where separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property in any of the following instances. Number 1, when the civil interdiction terminates. Number 2, when the absentee spouse reappears. Number 3, when the court being satisfied that the spouse granted the power of administration in the marriage settlements will not again abuse that power, authorizes the resumption of said administration. Number 4, when the spouse was left the conjugal home without the decree of legal separation, resumes common life with the other. Number 5, hindi with another, with the other. Kabati sila. Number 5, when parental authority is judicially restored to the spouse previously deprived thereof. Number 6, when the spouses who have separated in fact for at least 1 year reconcile and resume common life. Or number 7, when after voluntary dissolution of the absolute community of property or conjugal partnership has been judicially decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. The revival of the former property regime shall be governed by Article 67. Ayun, may Article 67. Article 142, the administration of all classes of exclusive, layo naman nun. Ulitin natin. The administration of all classes of exclusive property of either spouse may be transferred by the court to the other spouse kapag, number 1, when one spouse becomes the guardian of the other. Okay, yung ako, naging guardian ako ng asawa ko. Number 2, when one spouse is judicially declared an absentee. Number 3, when one spouse is sentenced to a penalty which carries with it civil interdiction. Yan, dinefine na natin kanina yung civil interdiction. Ibig sabihin, ipinagpapalagay ng batas na hindi niya kayang pumasok sa anumang uri ng kontrata, hindi niya kaya yung magbenta ng sarili niyang property, wala siya tamang pag-iisip, wala siyang karapatan, o basta wala siyang karapatan. Number 4, when one spouse becomes a fugitive from justice or is in hiding as an accused in a criminal case, kunwari may warrant of arrest, ayaw mo sumuko, nagtago ka, o hindi naman nahuli ka, tumakas ka sa bilangguan, yon ang mga dahilan. If the other spouse is not qualified by reason of incompetence, conflict of interest, or any other just cause, the court shall appoint a suitable person to be the administrator. Yun ay kung hindi kwalipikado yung naiwang asawa. Ay, nahulog yung aking stuffed toy. Okay, Chapter 6, Regime of Separation of Property. Okay, Article 143. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be governed by the regime of separation of property, the provisions of this chapter shall be suppletory. Article 144, separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. Hindi yan napag-usapan na magkahiwalay, matik kasama na yan. Article 145, each spouse shall own, dispose of, possess, administer, and enjoy his or her own separate estate without the need of the consent of the other. To each spouse shall belong all earnings from his or her profession, business, or industry, and all fruits, natural, industrial, or civil, due or received during the marriage from his or her separate property. Article 146, both spouses shall bear the family expenses in proportion to their income, or in case of insufficiency or default thereof, to the current market value of their separate properties. The liabilities of the spouse's creditors for family expenses shall, however, be solidary, o yung pagkakautang ng isang spouse. Di ba? Hindi. Yung pagkakautang ng sinuman sa mag-asawa na ginamit para sa expenses ng pamilya shall be solidary, o pwedeng singilin either of them. Kahit sino sa kanila, pwedeng singilin ng buo. Chapter 7, Property Regime of Unions Without Marriage. Nagsisimula ito sa Article 147 of the Family Code pa rin. Sabi rito, when a man and a woman who are incapacitated to marry ulitin natin. When a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. Kaya alam nyo, mas maganda pa yung hindi ka kasal eh. I'm sorry. Mas maganda pa yung pati yung sa property ninyo, yung co-ownership. Di ba? Patas pa rin naman eh. Kahit hindi kasal, mas patas pa nga. In the absence of proof to the contrary, properties acquired while they lived together presumed to have attained by their joint efforts, work, or industry and shall be owned by them in equal shares. So, di ba mas maganda ba? For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common without the consent of the other until after the termination of their cohabitation. When only one of the parties to avoid marriage is in good faith, the share of the party in bad faith in the co-ownership shall be forfeited in favor of their common children. In case of default of or waiver by any or all of the common children or their descendants, each vacant share shall belong to the respective surviving descendants. In the absence of descendants, such share shall belong to the innocent party. In all cases, a forfeiture shall take place upon termination of the cohabitation. Article 148. In cases of cohabitation not falling under preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions are corresponding shares. Their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in bad faith. Okay? Okay, maya-maya magsisimula na tayo sa Title 5, yung family, ng Family Code pa rin. Pag-uusapan natin dito, Chapter 1, the family as an institution. So, magbabalik po ako, dyan lamang kayo. Okay, hello at muling nagbabalik ang inyong lolo na si Lolo Ray para basahin pa rin ang Family Code of the Philippines. Title 5, The Family. Chapter 1, The Family as an Institution. Article 149, The family, being the foundation of the nation, is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law, and no custom, practice, or agreement destructive of the family shall be recognized or given effect. Okay. Article 150, family relations include those: number 1, between husband and wife; number 2, between parents and children; number 3, among brothers and sisters, whether of full or half blood. Okay. Article 151, no suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts toward a compromise have been made, but that the same have failed. If it is shown that no such efforts were in fact made, the same case must be dismissed. This rule shall not apply to cases which may not be the subject of compromise under the Civil Code. Kaya lang, masakit lang, no? Ako, sa experience ko, lalo na sa lola ko, yung mga kapatid niya, ang saswapang binakura nila yung lupa na hindi naman kanila. Di ba? Tapos sabihin ng korte, earnest efforts na bawiin yun. Pero pag binawi mo, gulo lang. Sisirain nila yung nilagay mo doon. Yan ang hirap lang, no? Kaya dapat sa magpapamilya, magkasundo kayo kasi napakapangit at napakabigat ng karma doon sa mga pamilyang sinaswapang nila yung kapwa nila. Chapter 2, The Family Home. Article 152. The family home, constituted jointly by the husband and the wife or by an unmarried head of a family, is the dwelling house where they and their family reside and the land on which it is situated. Article 153. The family home is deemed constituted on a house and lot from the time it is occupied as family residence. So, ibig sabihin, nabuo na ang family home doon sa tahanan at doon sa kung loteng kinititirikan noon. Yun na yung family home mo. From the time of its constitution and so long as any of its beneficiaries actually resides therein, the family home continues to be such and is exempt from execution, forced sale, or attachment, except as hereinafter provided and to the extent of the value allowed by law. Okay? Kasi mayroong value na inaalaw lang yung batas na manatili sa iyo ang iyong family home. It should not be subject of execution except doon sa mga provided ng batas. Article 154, the beneficiaries of a family home are, ito yung mga makikinabang sa family home. Number 1, the husband and wife or an unmarried person who is the head of the family. And number 2, their parents, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. Article 155, the family home shall be exempt from execution, forced sale, or attachment except, sabi niya, hindi raw exempted daw sa execution, forced sale, or i-attach yung property mo. Except, number 1, for non-payment of taxes. Number 2, for debts incurred prior to the constitution of the family home. Number 3, for debts, paliwanag natin number 2, yung mga pagkakautang na hindi mo nabayaran bago pa maokupahan ng family mo yung family home na yun, bago ma-constitute yung family home. Number 3, for debts secured by mortgages on the premises before or after such constitution. And number 4, for debts due to laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished material for the construction of the building. Okay, so yung pinagkakautangan mo sa mga labor ng gumawa ng bahay mo, etc. Yun, pwedeng makuha ang iyong family home, sabi nila. Kaya yung kapitbahay namin, meron kaming kapitbahay na swapang sila. Nakuha yung family home nila buo. Kasi naman, ah, marami na yata silang di binabayaran din sa milyar. Tapos marami silang sinanla nila yung bahay nila na may intensyong manloko. Pangatlo, mayroon naman silang pupuntahan na ibang lugar. So nakuha yung bahay nila. Article 156, the family home must be part of the properties of the absolute community or the conjugal partnership or of the exclusive properties of either spouse with the latter's consent. It may also be constituted by an unmarried head of the family on his or her own property. Nevertheless, property that is the subject of a conditional sale on installments where ownership is reserved by the vendor only to guarantee payment of the purchase price may be constituted as a family home. Article 157. The actual value of the family home shall not exceed, at the time of its constitution, the amount of 300,000 pesos in urban areas and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. In any event, if the value of the currency changes after the adoption of this code, the value most favorable for the constitution of a family home shall be the basis of evaluation. For purposes of this article, urban areas are deemed to include chartered cities and municipalities whose annual income at least equals that legally required for chartered cities. All others are deemed to be rural areas. Marami pa rin lugar sa Pilipinas ang rural areas. Article 158. The family home may be sold, alienated, donated, assigned, or encumbered by the owner or owners thereof with the written consent of the persons constituting the same, the latter spouse, and a majority of the beneficiaries of legal age. In case of conflict, the court shall decide. Ayun na nga. Yung sinanla ng majority ng owners ng family home, yung bahay ng kapitbahay namin, kaya sila napalis. Okay? So ano ba yung hinahanap natin? Meron tayong hinahanap na definition eh. Encumbered. Oh. Ang daming encumbered na nababasa tayo. Ano nga ba yung ibig niyang sabihin, 'di ba? Ano ibig sabihin? Sabi rito, restrict or burden in such a way that free action or movement is difficult. Okay, saddle a person or estate with a debt or mortgage. Yan. Fill or block up a place. Ayan. Ibig sabihin nun, yung nagpabigat ka dun sa tao. Saddle with a debt or mortgage. Okay. Yun ang ibig sabihin ng encumber. Okay. Inilubog mo yung isang ari-arian sa pagkakautang. Article 159, the family home shall continue despite the death of one or both spouses or of the unmarried head of the family for a period of 10 years or for as long as there is a minor beneficiary, and the heirs cannot partition the same unless the court finds compelling reasons therefor. This rule shall apply regardless of whoever owns the property or constituted the family home. Okay, kasi yung family home minsan, ang dami nyo nakatira sa inyong family house, paano nyo paghahati-hatian, hindi nyo pa ito pwedeng paghati-hatian kapag mayroon pang mga minor na beneficiaries. May mga minor pa doon. Article 160, when a creditor whose claims is not among those mentioned in Article 155 obtains a judgment in his favor, and he has reasonable grounds to believe that the family home is actually worth more than the maximum amount fixed in Article 157, he may apply to the court which rendered the judgment for an order directing the sale of the property under execution. Ganito yata rin yung nangyari doon sa kapitbahay namin na yung pinagkakautangan nila, pinagsanlaan nila na hindi nila binayaran, nakakuha siya ng judgment ng korte ng favorable sa kanya, kung kaya't napalis yung mga dating nakatira doon. The court shall so order if it finds that the actual value of the family home exceeds the maximum amount allowed by law as of the time of its constitution. If the increased actual value exceeds the maximum allowed in Article 157, and results from subsequent voluntary improvements introduced by the person or persons constituting the family home, by the owner or owners of the property, or by any of the beneficiaries. The same rule and procedure shall apply. At the execution sale, no bid below the value allowed for a family home shall be considered. The proceeds shall be applied first to the amount mentioned in Article 157 and then to the liabilities under the judgment and costs. The excess, if any, shall be delivered to the judgment debtor. Okay? Okay, sa execution sale daw, yung sobra, isusoli doon sa nangutang. Okay, nanalo na nakuha na nung pinagkakautangan yung kanya. Yung sobra, babalik na doon sa judgment debtor. Article 161, for purposes of availing of the benefits of a family home, as provided for in this chapter, a person may constitute or be the beneficiary of only one family home. Iisa lamang ang pwede mong masabi o may constitute na family home. Article 162, the provisions in this chapter shall also govern existing family residences insofar as said provisions are applicable. Punta na tayo sa Title 6, Paternity and Filiation, Chapter 1, Legitimate Children. Sisimula itong chapter na ito sa Article 163 ng Family Code pa rin. The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. Article 164, children conceived or born during the marriage of the parents are legitimate. Of the parents, o pinanganak ka, nabuo ka, tapos pinanganak ka during the marriage, you are a legitimate child. Children conceived as a result of artificial insemination of the wife with the sperm of the husband, or that of a donor, or both, are likewise legitimate children of the husband and his wife, provided that both of them authorize or ratify such insemination in a written instrument, executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. So, ang ibig lamang na sabihin nun, kunwari may mag-asawa, ngayon, kailangan nila yung aking semilya. Ako ay sperm donor. Nag-donate ako ng sperm. Hindi ko chinorba yung wife, kundi nag-donate ako ng sperm na gagamitin for artificial insemination. As long as yung mag-asawa pumayag at hindi yung iisang panig lamang at nabuo, ipinagbuntis niya yung baby na yon, pumayag sila sa written instrument, may kasulatan, yun po ay considered legal na anak nilang dalawa. Pero kung itong si girl, nilandi niya lang ako, nagpatunate ng sperm, di naman pumayag yung asawa niya, gulo yun. Okay? Walang liability itong lalaki doon. Article 165, children conceived and born outside the valid marriage are illegitimate unless otherwise provided in this code. Article 166, legitimacy of a child may be impugned only on the following grounds. So, para sa mga katulad kong ordinaryong tao lamang, anong ibig sabihin ng impugn? Sabi, may be impugned. Anong ibig sabihin? To assail by words or arguments, to oppose or attack as false or lacking integrity. So, ibig sabihin ng impugn ay kontrahin. Okay? Sabi rito, yung legitimacy of a child may be impugned or kontrahin only on the following grounds. Number 1, that it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of, ibig sabihin, imposible. Hindi kami pwedeng nag-sex nitong wife ko within the first 120 days of the 300 days which immediately preceded the birth of the child. So, kunwari, pinanganak yung child ng November 1, bibilang ka pabalik, 300 days. Yung first 120 days nun, imposibleng nagchorba kami dahil letter A, the physical incapacity of the husband to have sexual intercourse with his wife. Kunwari, siya ay impotent, hindi tumatayo. Letter B, the fact that the husband and wife were living separately in such a way that sexual intercourse was not possible. Letter C, serious illness of the husband which absolutely prevented sexual intercourse. At yun yung mga facts na. At number 2, that it is proved that for biological or other scientific reasons, the child could not have been that of the husband except in the instance provided in the second paragraph of Article 164. Kunwari, DNA test. Ayan. Kaya kung may duda kayo at may pera lang din kayo, pa-DNA test kayo. Or doon sa mga nagdududa na kayo yung ama ng bata, ayun. Hintayin nyo ipanganak, saka kayo magbilang. Pinanganak yung bata sa date na ito, bilang ka pabalik 300 days. Doon sa first 120 days na yon. Okay. Tapos, saan ba ako? Number 3, that in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. Okay? Kunwari, yung ibig lamang sabihin nun, kunwari, yung example ko kanina, artificial insemination, nagdo-donate. Pumayag, kunwari, yung asawa, pero tinakot lang pala siya, or pineke yung pirma niya, fraud, yan. Or by mistake, yeah. Okay, Article 167. The child shall be considered legitimate, although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. So kahit nasintensyahan mo yung kahit nasintensyahan pa ang sinumang ina na siya ay adulteress, pwede pa rin kilalanin ang isang batas na legal o legitimate na anak. Article 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. So ito yung mga ngasiwang, ito yung mag-govern. Kung kunwari ang isang ina, nabalo siya, ay ang isang babae, nabalo, sa loob ng 300 days, kinasal siya. Ito yung rules na yon. Number 1, a child born before 180 days after the solemnization of the subsequent o yung kasunod na marriage is considered to have been conceived during the former marriage provided it be born within 300 days after the termination of the former marriage. Basta ipanganak siya 300 days matapos ang pagtatapos ng former marriage o matapos yung kamatayan kung nabiyuda man yung babae. Number 2, a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage even though it be born within the 300 days after the termination of the former marriage. Article 169. The legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. Yung nag-aakusa, siya ang magpapatunay. Article 170, the action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register if the husband, or in a proper case, any of his heirs should reside in the city or municipality where the birth took place or was recorded. If the husband, or in his default, all of his heirs do not reside at the place of birth as defined in the first paragraph or where it was recorded, the period shall be 2 years if they should reside in the Philippines, and 3 years if abroad. If the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or of the fact of registration of said birth, whichever is earlier. Article 171. The heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. Okay? So, yung mga tagapagmana ng isang lalaki o ng husband, pwede lang nilang kontrahin yung filiation ng isang bata within the period prescribed in the preceding article only in the following cases. Number 1, if the husband should die before the expiration of the period fixed for bringing his action. Number 2, if he should die after the filing of the complaint without having desisted therefrom. Or number 3, if the child was born after the death of the husband. Tungo na tayo sa Chapter 2, Proof of Filiation. Article 172. The filiation of legitimate children is established by any of the following. Number 1, the record of birth appearing in the civil register or final judgment, or number 2, an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by number 1, open and continuous possession of the status of legitimate child, or number 2, any other means allowed by the rules of court and special laws. Article 173, the action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. 5 years, okay? Article 174, legitimate children shall have the right to, number 1, to bear the surnames of the father and the mother in conformity with the provisions of Civil Code on surnames. Number 2, to receive support from their parents, their ascendants, o yung kanilang mga lolo, and in proper cases, their brothers and sisters in conformity with the provisions of this code on support. And number 3, to be entitled to the legitimate and other successional rights granted to them by the Civil Code. Chapter 3, illegitimate children. O, ito naman. Article 175, illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173, except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. Article 176, illegitimate children shall use the surname and shall be under the parental authority of their mother. Pero meron ng Revilla Law, pwede nang gamitin yung pangalan yung apelido ng tatay kung sila ay kinilala, and shall be entitled to support in conformity with this code. However, illegitimate children may use the surname of their father. O, wag na yan. Meron ng ano yan Revilla Law. Chapter 4, legitimated children. Ano naman itong mga to? Article 177. Children conceived and born outside of wedlock of parents who, at the time of conception of the former, were not disqualified by any impediment to marry each other, or were so disqualified only because either or both of them were below 18 years of age, may be legitimated. So, yung mga pinanganak, kunwari, nagkabuntisan, yung dalawang 17 years old, di ba sila pwede ikasal? So, at wala naman silang legal impediment. Hindi lang sila pwede ikasal kasi may minor de edad pa sila. So, pagdating ng panahon na pwede na sila ikasal, yung mga anak na ipinanganak bago sila ikasal ay pwedeng gawing legitimated children. O di naman, yung magjowa, nagsasama sila, wala naman silang legal impediment. Nagkabuntisan sila, nasa tamang edad na sila, pero hindi sila kasal. Tapos pag kinasal sila, pwedeng maging legitimate yung kanilang mga anak. Article 178, legitimation shall take place by a subsequent valid marriage between parents. So yun lang pala yun. Kunwari, ako, ilang taon na ako, 25 na ako. Meron akong nabuntis, 25 years old na rin siya. So, illegitimate yung anak namin, hindi pa kami kasal. Ngayon, pag kinasal na kami, legitimated na yung aming mga anak. Article 179, legitimated children shall enjoy the same rights as legitimate children. Article 180, the effects of legitimation shall retroact o babalik to the time of the child's birth. Article 181, the legitimation of children who died before the celebration of the marriage shall benefit their descendants. Okay. Article 182, legitimation may be impugned o pwede lamang kontrahin only by those who are prejudiced in their rights within 5 years from the time their cause of action accrues. So, pansinin nyo, dun sa mga provision na ito, within 5 years mo lamang pwedeng i-contest mula nung nagkaroon ka ng cause of action o ng dahilan para i-contest ito. Okay? Title 7, Adoption. Article 183, a person of age and in possession of full civil capacity and legal rights may adopt, provided he is in a position to support and care for his children, legitimate or illegitimate, in keeping with the means of the family. Only minors may be adopted. So ako, dahil 25 years old na ako, hindi na ako pwedeng i-adopt. Except in cases when the adoption of the person of majority age is allowed in this title. In addition, the adopter must be at least 16 years older than the person to be adopted. So dapat, kung kunwari, ako ay 16 years old, ang mag-a-adapt sa akin should be, at least be 32 years old. Or is the spouse of the legitimate parent of the person to be adopted. Okay? So, hindi man siya 16 years older sa akin, at least man lang siya ay nasa tamang edad na at siya ay asawa ng isa sa aking legal na magulang. Article 184, the following persons may not adopt. Ito yung mga hindi pwedeng mag-adopt. Number 1, the guardian with respect to the ward prior to the approval of the final accounts rendered upon the termination of their guardianship relation. Ayan. Number 2, any person who has been convicted of a crime involving moral turpitude. Number 3, an alien except a former Filipino citizen who seeks to adopt a relative by consanguinity. So, bawal daw mag-adopt ang isang alien except kung siya ay dating Filipino citizen na gustong mag-adopt ng relative by consanguinity. O kaya naman yung isang tao who seeks to adopt the legitimate child of his or her Filipino spouse. Ang example niyan, merong kano. Hindi naman siya dating citizen ng Pilipinas, pero nag-asawa siya ng Pilipina. Gusto niya na rin i-adopt yung anak nung napangasawa niya. Yun, pwede yun. And letter C, one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse a relative by consanguinity of the latter. Ibig sabihin nito, anak, o di naman kapatid, yan. Aliens not included in the foregoing exceptions may adopt Filipino children in accordance with the rules on inter-country adoptions as may be provided by law. So, yung mga dayuhan na gusto mag-adopt ng mga Pilipino na pinapayagan ng batas, kailangan nilang basahin yung inter-country adoptions. Executive Order 91 and PD 603. Article 185. Husband and wife must jointly adopt except in the following cases. Dapat jointly silang mag-a-adopt yung mag-asawa except number 1, when one spouse seeks to adopt his own illegitimate child, or number 2, when one spouse seeks to adopt the legitimate child of the other. Article 186, in case husband and wife jointly adopt or one spouse adopts the legitimate child of the other, joint parental authority shall be exercised by the spouses in accordance with this code. Article 187, the following may not be adopted. Ito yung hindi pwedeng ampunin. Number 1, a person of legal age unless he or she is a child by nature of the adopter or his or her spouse, or prior to the adoption, said person has been consistently considered and treated by the adopter as his or her own child during minority. Number 2, an alien with whose government the Republic of the Philippines has no diplomatic relations. And number 3, a person who has already been adopted unless such adoption has been previously revoked or rescinded. Article 188, the written consent of the following to the adoption shall be necessary. Ito yung nangangailangan. Ito yung kailangan ng kanilang written consent. Number 1, the person to be adopted if 10 years of age or over. Number 2, the parents by nature of the child, the legal guardian, or the proper government instrumentality. Number 3, the legitimate and adopted children 10 years of age or over of the adopting parent or parents. Number 4, the illegitimate children 10 years of age or over of the adopting parent, if living with said parent, and the latter spouse, if any. And number 5, the spouse, if any, of the person adopting or to be adopted. Superseded na raw to ng EO 91 and PD 603. Basahin niyo yung adoption. Pero may mga provisions pa rin dito sa adoption ng family code na makapangyayari. Article 189, adoption shall have the following effects. Number 1, for civil purposes, the adopted shall be deemed to be a legitimate child of the adopters, and both shall acquire the reciprocal rights and obligations arising from the relationship of parent and child, including the right of the adopted to use the surname of the adopters. Number 2, the parental authority of the parents by nature over the adopted shall terminate and be vested in the adopters, except that if the adopter is the spouse of the parent by nature of the adopted, parental authority over the adopted shall be exercised jointly by both spouses. And number 3, the adopted shall remain an intestate heir of his parents and other blood relatives. So malinaw naman yun. For civil purposes, sabi lamang, ipagpapalagay ng batas na ang isang inampon sa legal na paraan ay isang legal na anak, legitimate child. Yung parental authority ng parents by nature over the adopted shall terminate. So yung parental authority ng tunay na magulang ay mawawala na at may lilipat na doon sa nag-ampon sa kanya ng legal. At number 3, yung adopted, yung inampon ay mananatiling legal na tagapagmana ng kanyang biological parents. So magiging legal siyang tagapagmana ng mga umampon sa kanya. Legal na tagapagmana pa rin siya ng kanyang pinanggalingang tunay na mga magulang. Article 190. Legal or intestate succession to the estate of the adopted shall be governed by the following rules. Number 1, legitimate and illegitimate children and descendants and the surviving spouse of the adopted shall inherit from the adopted in accordance with the ordinary rules of legal or intestate succession. Number 2, when the parents, legitimate or illegitimate, or the legitimate descendants of the adopted concur with the adopter, they shall divide the entire estate, one half to be inherited by the parents or ascendants and the other half by the adopters. And number 3, when the surviving spouse or the illegitimate children of the adopted concur with the adopters, they shall divide the entire estate o yung pag-aari in equal shares, one half to be inherited by the spouse or the illegitimate children of the adopted and the other half by the adopters. Number 4, when the adopters concur with the illegitimate children and the surviving spouse of the adopted, they shall divide the entire estate in equal shares, 1/3 to be inherited by the illegitimate children, 1/3 by the surviving spouse, and 1/3 by the adopters. So nakalagay dito yung mana-mana ng mga inadopt-adopt. Number 5, when only the adopters survive, they shall inherit the entire estate ng kanilang inadopt. And number 6, when only collateral blood relatives of the adopted survive, then the ordinary rules of legal or intestate succession shall apply. Okay. Article 191, if the adopted is a minor or otherwise incapacitated, the adoption may be judicially rescinded upon petition of any person. Sandali lamang. Upon petition of any person. Nasaan na ako? Bigla ako nawala eh. Rescinded upon petition of any person authorized by the court or proper government instrumentality siguro to, acting on his behalf on the same grounds prescribed for loss or suspension of parental authority. If the adopted is at least 18 years of age, he may petition for judicial rescission of the adoption on the same grounds prescribed for disinheriting an ascendant. Article 192, the adopters may petition the court for the judicial rescission of the adoption in any of the following cases. Number 1, if the adopted has committed any act constituting ground for disinheriting a descendant, or number 2, when the adopted has abandoned the home of the adopters during minority for at least 1 year or by some other acts has definitely repudiated the adoption. So pwedeng i-rescind o ipawalang bisa ang isang pag-a-adopt nung mga nang-adopt kapag yung inampun nila naggawa ng mga acts na ground para ipawalang mana ito kunwari pinagtangkaan yung buhay mo o sumiping doon sa nag-ampon sa kanya, o number 2, kapag yung inampun iniwan niya yung tahanan niya for at least 1 year o iba pang acts na definitely repudiates the adoption. Article 193, if the adopted minor has not reached the age of majority at the time of the judicial rescission of the adoption, the court in the same proceeding shall reinstate the parental authority of the parents by nature unless the latter are disqualified or incapacitated in which case the court shall appoint a guardian over the person and property of the minor. If the adopted person is physically or mentally handicapped, the court shall appoint in the same proceeding a guardian over his person or property or both. Judicial rescission of the adoption shall extinguish all reciprocal rights and obligations between the adopters and the adopted arising from the relationship of parent and child. The adopted shall likewise lose the right to use the surnames of the adopters and shall resume his surname prior to the adoption. The court shall accordingly order the amendment of the records in the proper registries. Tungo naman tayo dito sa Title 8, Support. Although nagbasa na tayo ng support na nakalagay pa rin sa Civil Code, basahin natin yung support na nakalagay sa Family Code. Family Code. Parehas lang eh. Okay. Babasahin na rin natin. Article 194, support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. The education of the person entitled to be supported referred to in the preceding paragraph shall include his schooling or training for some profession, trade, or vocation, even beyond the age of majority. So ako, pinag-aaral ako ng mga magulang ko ng law kahit na beyond the age of majority na ako. Transportation shall include expenses in going to and from school or to and from place of work. Article 195, subject to the provisions of the succeeding articles, the following are obliged to support each other to the whole extent set forth in the preceding article. Number 1, the spouses, legal na mag-asawa. Number 2, legitimate descendants and descendants. Number 3, parents and their legitimate children, and the legitimate and illegitimate children of the latter. Number 4, parents and their illegitimate children and the legitimate and illegitimate children of the latter. So yung magulang, yung mga anak nila, yung mga legal at at anak sa labas ng kanilang mga anak, obligado kang i-support sila. And number 5, legitimate brothers and sisters whether full or half blood. So yung kapatid mo sa ama o yung kapatid mong full blood ay obligasyon mong suportahan, sabi. Article 196, brothers and sisters not legitimately related, whether of the full or half blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister being of age is due to a cause imputable to the claimant's fault or negligence. Article 197, in case of legitimate descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obliger has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. ko. Article 198, during the proceedings for legal separation or for annulment of marriage and for declaration of nullity of children, the spouses and their children shall be supported from the properties of the absolute community or the conjugal partnership. After the final judgment granting the petition, the obligation of mutual support between the spouses ceases. However, in cases of legal separation, the court may order that the guilty spouse shall give support to the innocent one, specifying the terms of such order. So yung nagtaksil, pwedeng suportahan niya pa rin ang kanyang asawa pag sinabi ng korte ito. Article 199, whenever two or more persons are obliged to give support, the liability shall devolve upon the following persons in the order herein provided. Okay, number 1, una-una, the spouse. Ito yung pagkakasunod-sunod. Number 2, the descendants in the nearest degree. Number 3, the ascendants. Mga pinanggalingan mo in the nearest degree. And number 4, the brothers and sisters. Article 200, when the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may order only one of them to furnish the support provisionally without prejudice to his right to claim from the other obligers the share due from them. Diba kasi laging binabayaran po yung mga utang, ano? When two or more recipients at the same time claim support from one and the same person legally obliged to give it, should the latter not have sufficient means to satisfy all claims, the order established in the preceding article shall be followed unless the concurrent obliges should be the spouse and a child subject to parental authority, in which case the child shall be preferred. Inuuna po ang bata. Article 201. The amount of support in cases referred to in Articles 195 and 196 shall be in proportion to the resources or means of the giver and to the necessities of the recipient. Siyempre, dapat proportion. Article 202, support in the cases referred to in the preceding article shall be reduced or increased proportionately according to the reduction or increase of the necessities of the recipient and the resources or means of the person obliged to furnish the same. Article 203, the obligation to give support shall be demandable from the time the person who has a right to receive the same needs it for maintenance, but it shall not be paid except from the date of judicial or extrajudicial demand. Support pendente lite may be claimed in accordance with the rules of the court. Payment shall be made within the first 5 days of each corresponding month, or when the recipient dies, his heirs shall not be obliged to return what he has received in advance. Alagay ito sa Civil Code, yung provision ng Civil Code sa support. Article 204. Nabasa na natin lahat ng to Parental authority. Nabasa na natin to doon sa emancipation, nabasa na natin ang lahat na to. So, doon po nagtatapos ang ating pagbabasa ng ating family code. Yung iba po, kumbaga, isinasama ko po itong family code doon sa book 1 pa rin. Dito nagtatapos ang pagbabasa ng ating book 1. At parang may dalawa yata akong binasa na live na para sa book 1 ng Civil Code. Next time, itutuloy natin. Babasa pa rin tayo ng Civil Code, pero magsisimula na tayo sa book 2. Tapos na yung tungkol sa pamilya, tungkol na sa property. Ang babasahin natin, ownership, co-ownership, special properties, possession, use of right, na ibig sabihin yan, easements. Napakarami pa po about Civil Code ang ating kailangan basahin. At gusto kong ibahagi sa inyo sa mga susunod. So, dyan po nagtatapos ang ating book 1. Okay. God bless you. And sana next time samahan niyo ulit ako magbasa at subukang ipaliwanag ang batas in layman's terms. God bless.